thank you very much for joining us today. My name is Ian Scott, and I am the founder of Scott Legal and also the managing partner of Scott Legal. And today we are going to talk a little bit about visas and moving from a visa to a green card and the various options associated with that. So there are a number of topics that we're going to cover when we go through this. But before we get started, let's just cover a few housekeeping items. So first and foremost, this webinar is going to be recorded, so you are going to receive a copy of the recording along with another number of other things. You'll receive the PowerPoint presentation. You'll also receive information on how you can set up a consultation. You'll receive a link to our YouTube channel where this video will be posted, and we recommend subscribing to that channel because we regularly post videos. The other thing I wanted to point out is that we're going to talk about a number of different visas and green cards today. And for each of these green card options, we could have a separate webinar. And in fact, we do have separate webinars for each of these green card options where for example, the national interest waiver, that's a webinar in itself. We hold a couple of those every month, and that could take up 1 hour in itself. So we are just going to touch on the green card options, but you will have some basis or some summary for those options, and then you'll be able to utilize that to perhaps attend another webinar or get more information on something that might be relevant to you. To the extent that you do have a question during the presentation, you can utilize the chat box or the question and answer box. We will get to all questions before the end of the webinar. And again, the final thing that I would say is just that we will send out guides that really relate to each of these different green card topics that we talk about. So the guide will have comprehensive information regarding each of those topics, so that could be helpful for you as well. And again, though, keep in mind that for each of these topics, we do have separate webinars, so that's something that you can partake in the future just by signing up on our website, and all of those webinars are free. So before we get into the different options, let's just talk about the green card system in the United States a little bit. So the green card system in the United States is a little different from most countries. And when I say it's different, I mean that the system in most countries, they have what's called a points-based system. And that system really allows people to accumulate points based on a number of different things. So speaking the language, maybe your education level, your work experience level, your age, different things like that. And then once you accumulate a certain number of points, then you're able to get permanent residency. Sometimes they even take into account how long you've been in the country, lawfully, how long you've been in the country. So all of those things are taken into account. But in the US, unfortunately, they don't use a system like that. They use a completely different system. And the system that they use is just that there are a list of green card categories. And if you're eligible for a green card, you can apply for it. So, and unfortunately, none of the other non-immigrant visa categories, so the visas the non-immigrant visas, whether it's TN, E2, L1, H1B, O1, none of the non-immigrant visa categories actually lead to a green card. So that's something to keep in mind, and just to keep in mind that the way that the system works here is that you have to look at the particular green card category and then make an assessment as to whether or not you qualify. Do you meet the criteria that are listed in that particular category, and then apply. And then keep in mind that the criteria is there's never going to be a criteria that is, well, you've had a non-immigrant visa for a particular period of time. Unfortunately, that's not the way it works. Usually the criteria are criteria that are quite specific and related to the particular visa category, the green card category. And we're going to get into those as we talk about the different available categories. So broadly speaking, and there are other green card categories, but broadly speaking, the green card system is broken up into two major categories, and that's family-based and employment-based. Now, when you look at the family-based and employment-based categories, both of these have limits, numerical limits. And I think it's something that to keep in mind as we go through this, is that each year Congress can only give out a certain number of green cards, right? And the reason this is important is because, especially today, most of the categories are backlogged, because once they use that particular number, then people go on to what are just really called waiting lists, right? That's what they go into, and that significantly impacts the time period associated with getting the visa or the green card. And we use visa and green card synonymously. So let's first talk about family-based. So family-based green cards are broken up into two categories. One is immediate relative category, and the second is preference-based category. Now, the reason that we love the immediate relative category, so that's something like U.S. citizen marrying someone, or U.S. citizen child over 21 sponsoring a parent. Now, it's not immediate relative in the way that we think of it. So it's not like sibling or anything like that. Or even a parent sponsoring a child that's over 21. It's not immediate relative like that. It's immediate relative as defined by the law. And the reason we love the immediate relative category is because there are no numerical limits in this particular category. So that means that the green card is always available. So if you had a 21-year-old that was sponsoring their parents for a green card, the green card category would always be available to them, and the weights would not be as extensive. If you contrast that to the preference-based category, so for example, there's a preference-based category related to U.S. citizen sibling sponsoring brother or sister, and that particular category is backlogged for 14 years. So there's no practical benefit that a brother or sister could get from that particular category for 14 or 15 years. So that's the kind of difference, the difference. And what it is, the categories are broken up, F1, F2, F3, etc. And then you have to go on a schedule to see which ones are current. But unfortunately, every single category right now is backlogged, except for, of course, the ones that can't be backlogged, the immediate relative category. So, but what we do have often in terms of people moving from a green card is, they're on a particular visa and then they meet a U.S. citizen and adjust status to get a green card, or they either have a parent, sorry, U.S. citizen child that turns 21 and they get it that way. But that's often a mechanism for getting a green card is through family. The second largest mechanism is through employment-based, and we're going to go through each of these as well. But the employment-based categories are listed as EB1 through EB5. The only one we're not going to talk about is EB4, which is a religious-based green card, which we don't do any of those. But EB1 through EB5, we're going to talk about those. And I think that it's important to think about these in terms of, again, the very specific criteria associated with each of these green cards and having to meet them. And as we go through each of them, we'll talk about those in a little bit more detail. So let's start with the first one. Let's start with let's start with what we started talking a little bit about family-based green cards, and we talked about the immediate relative, and I gave an example of U.S. citizen spouse marrying, so U.S. citizen marrying their spouse, and I gave an example of the preference-based as well. Now, one of the things that I wanted to talk about here, and really utilize this to talk about in terms of every single category, right, is the 2 or 3 step process. So getting a green card in the United States is always going to be either 2 or 3 step process. So let's use 2 examples. The one, and both for family-based. So if you are a U.S. citizen, if you're under the immediate relative category and you're sponsoring your spouse, so let's say someone's on TN visa and then they meet the love of their life, they marry, and then that person happens to be a U.S. citizen and that person sponsors them for a green card. So sure, getting a green card is not a problem. The green card is available and you can apply for the green card. And the process, though, is going to involve a number of steps. So step 1 is going to be filling out something that shows you met the objective requirement. So you've married a U.S. citizen. So in this case, it's going to be an I-130. Then step 2 is going to be either filing an I-485. So if you're in the United States and the category is current, then you can file an I-485, or it's going to be doing consular processing. So getting the visa, the green card at the actual consulate. So that's going to be step 2. Now, the interesting thing with this particular green card is there's a third step, because when you get the green card, unfortunately, all you get is what's called a conditional green card. And then you have to remove those conditions in 2 years. So there's another petition that has to be filed called an I-751 after a 2-year period. So that's a 3-step process. So in that particular case, it's a 3-step process. Now, if you look at the sibling one, though, that I mentioned earlier, and let's say someone went through that process, and let's say they waited the 14 years, and then the green card category finally became current, and they applied for the green card, then that's going to be a 2-step process, because there is no third step. Once the person gets the green card, they're actually going to get an unconditional green card. So it actually is going to be a 2-step process. But what all of these green cards we talk about they're all similar in that regard, in that there's either going to be a two-step process or a three-step process. And whenever you're looking at that two or three-step process, you're always going to have to ask yourself the question of whether or not the green card is available, whether it's current. And unfortunately, many of the categories right now are backlogged. So getting that current status is something that's going to be, that right now is very, very difficult. So there are delays, and it's just a matter of how long those delays are. And then if you're from particular countries, it could be much longer. If you're from India or China, the delays could be much, much longer. So now let's look at the first employment-based category. And this one is extraordinary ability, EB1A. And what this one, normally what we see in terms of non-immigrant visas or people who are on a visa, usually someone might be on an O1 visa. And an O1 visa is the little brother or sister of this particular category, this green card category. And really what this is saying is that it's similar to the O1, in that it's saying that the person has risen to the top of their field, and they have, they have extraordinary ability. They've risen to the top of their field, and they have extraordinary ability in this in a particular area. And what we use to assess that are the 8 or so bullet points that are listed here. So let's say the person was selected to judge the work of others, or they commanded a high salary. Both of those things are indicating that maybe the person has risen to the top of their field. So that's that's a good indication that they actually are people who might deserve a green card because of this, with utilizing this particular category. But you do have to meet at least 3 of the criteria, and some, we often encourage people to meet more, because with this category, the more you meet, the better, because even if you meet the 3, there's a secondary analysis that's done that looks at whether or not you've risen to the level, it's very subjective, risen to the level of extraordinary ability. So that's something to keep in mind. The one good thing about this particular category is that you can self-petition, so you don't need an employer. So you could have extraordinary ability, and then you could actually file a petition on your own behalf. And even an entrepreneur could file this. We've done extraordinary ability petitions for entrepreneurs. For example, we use in the judging category, we show that this particular entrepreneur used to sit on committees that would decide who would get the investment, like if there were other companies that were pitching for particular investments. So they were judging in that capacity. We've showed that they, whatever business they've started, they've created novel new techniques or way of doing business. So we say their business-related contributions were of major significance in the field. So definitely for entrepreneurs can apply in this category. And this is always going to be a 2-step process. So the first step of the process is going to be filing an I-140, and the I-140 is going to show that you've met at least 3 of the criteria that are listed here. And then if the category is current, and this category does happen to be current for most countries, then you would be able to, if you're in the US, you'd be able to file the I-485. But if not, you have to wait until the I-140 has been approved and then do consular processing. Now, keep in mind that this category does allow for premium processing, so you can pay the government some extra money. I think it's a little over $2,500, and have the petition approved adjudicated anyway, within 15 days. So that's something to keep in mind. And again, the primary visa type that people move from to EB1A is O1. So either O1A or O1B. So that's something to keep in mind. Now, the second visa type that a lot of people move from non-immigrant visas to green cards is national interest waiver. And this has become extremely popular after 2017, when they changed the standards for adjudicating these. And we do a lot of national interest waivers now, and we're quite strategic and thoughtful with respect to how it is we position certain cases, because the legal standard is a tough and high bar. However, there is a lot of opportunity to meet the bar, and good lawyering, I think, sometimes can be very effective, because there are a lot of cases that the appeals board has written summaries on you can utilize to assist you with respect to proving a particular point when you're arguing that you've met the national interest waiver requirements. But really here, what you're looking at is that the first thing you're always doing with the national interest waiver petition is looking at what the reason that the person is coming to the United States, right? So that's the first thing that you're looking at, is why are they coming to the United States? Now, now that they have come to the United States, and why is that important? So when you're looking at the reason they've come to the United States, so the endeavor, then the question is, why is that of national importance, and why does that particular thing have substantial merit? Now, it could be that the person is creating jobs, so that's, creating economic benefit, and that has substantial merit. It could be that the person is, whatever the person's creating, let's say they're creating widgets and the government feels that widgets are important, then that could be something that is of national importance. So really, you're looking at what it is the person is going to be doing, and sometimes kind of assessing. Sometimes I'll be in a consult, and then they'll say, someone the other day said, "Oh, I'm in the semiconductor industry. I assist with that," and I kind of use ChatGPT to kind of say, okay, why is the semiconductor industry important to the U.S. government? And it gave me like 5 different reasons why, and then you would expand on those. But you also have to look at what the person is doing and make sure that it's specifically relevant, because sometimes like buzzwords don't cut it. Like sometimes people will come and say, "Oh, I'm in supply chain management," because they've heard buzzwords that the U.S. government is interested in supply chain management. But then you say, "So can you explain to me what you mean?" And then it has nothing to do really with supply chain management. But I think that you do have to take a deep dive with respect to what it is the person's doing or coming to the U.S. to do, and sometimes expert letters can help with linking what someone is doing to national importance. But that's really where you're going with this in terms of what you're trying to prove. And often expert letters, as I said, can help with this. And sometimes, definitely, what the government writes about a particular thing. If cybersecurity is important to the government, often they'll write about it. If artificial intelligence is important, they'll write about it. The government has said that they feel people in STEM fields are important, and that's in the national interest. So all of those types of things we utilize in a national interest waiver petition. The second part of this is that the person's well positioned to advance the endeavor. And this one, we're going to look at the person's background or education, but more importantly, because that's going to be a given, the background and education. But more importantly, we're going to look at the track record. Have they done what they said that they want to do before? Because the government's not just going to take the word for it that they're going to do it. If they're an entrepreneur, do they already have funding? If people already invested? Do they have patents? Do they have things that show that do they have contracts already? Do they have things that show that they can accomplish what it is they say that they're going to do? Because it's well positioned to advance the endeavor that you talked about in the first place, right? In part 1. So I think that this can be something that it sounds straightforward, but unfortunately, it's probably the area where the highest reason that national interest waiver petitions are actually denied, because you can always kind of position the first prong as something that is important, but then if make it grand and things like that, but then the government says, well, are you well positioned to advance what it is that you said that you would do? And that can sometimes be problematic. So then the final is that final prong is that the government should waive the labor certification. We'll use arguments from 1 and 2, the prongs 1 and 2, but then also anything else interesting about the applicant that we can argue that the government should waive the labor certification. So that's something that. Now, the other thing you can keep in mind with this particular green card is that there are threshold considerations here. So this is under the EB2 category. So before you even start looking at whether you can qualify under DANISR, that's the name of the case, you do have to make sure you have at least one of these 3 things. So you either have to have an advanced degree, so that's a master's degree or higher. You either have to have a bachelor's degree plus 5 years of experience, progressive work experience, or exceptional ability. Exceptional ability, there are a list of 7 things, and you have to meet at least 3 of them. But before, and that's the easy part, right? That's a lot of people actually get confused. They'll set up a consult with this, and they'll say, well, I meet the standard because I have an advanced degree. Well, that's just the threshold issue before you can even start looking at the 3 DANISR prongs, which are the difficult side. So now with this, the process is that this is a 2-step process where you're going to file an I-140 to prove the 3 DANISR prongs. And then you are going to file an I-485 or consular processing, depending on whether the category is current. Right now, the category is not current for any country. There's small delays, like maybe a year delay for most countries, and then much longer delays for India and China. So the next category of green card is a company sponsoring you for a green card. So, so let me just back up one sec. Now, for EB2 national interest waiver, often we see clients moving here that were on H-1B. So they might be an engineer or something like that. They were able to get an H-1B job, and then the company sponsors them, and they have the qualifications or some other STEM field. The other area is E2, people that have been on E2s, and then we can make the argument, an economic benefit argument, or what their E2 business is. We can find things that the government finds appealing or of national importance with respect to the business that they're coming from. But those are probably the two areas we see the most. H-1B, maybe some TNs as well, and E2s. So the next category of EB2 and EB3, that is companies sponsoring you for a green card. So this is, probably a really, it's a big, significant way that people get a green card in the US. They come in as a TN, they come in as an H-1B, someone's here on an E2 and their spouse has work authorization, they go work for a company, and then the company decides to sponsor any of those people for a green card, and they sponsor them under EB2 or EB3. EB2 is just kind of on the professional level, and EB3 can open up the door for unskilled workers in other areas. Now, EB2, keep in mind, that's the same EB2 that we just talked about with respect to national interest waiver. So you would have to meet threshold requirements to qualify there. But if you didn't meet threshold requirements to qualify there, you might be able to still get sponsored under EB3, which doesn't have those threshold requirements. And it's a three-step process for a perm. So first, it's the perm, which is the Department of Labor piece, where you're proving to the US government that you can't find a qualified US person. So that actually is creating a job description, posting it, interviewing people. It is quite a process, and it takes over a year and a half to complete that process. The second part is the I-140. That's a bit more basic often. And then the I-485 or the consular process, depending on whether your category is current and whether you're in the US or not. And the perm, as I said, it is, we listed some kind of things, bullet points that are here, but the perm is quite a process, time consuming, and given there is no real job, it's something that you have to, it's not for the faint of heart. Now, keep in mind as well that if you're on an E2 and you want to move to a green card, you can't sponsor yourself and you can't sponsor your family members, right? So just keep that in mind. There's no ability to do that if you're on E2. And the next area where people move to a green card is EB5. Often this combination, again, of different types of visas where people move. So often people will be on student visas, F1, and then they have the money, or their parents have the money to lend the money to invest in regional center or start their own business. The other area is E2. So people will have a business and they've invested money, and then they are investing money over time. And they are, investing money over time. And then when they make those investments over time, they add them all up and they come up with the 800,000 or 1,050,000. But what this particular category requires is it requires that the person invest either 800,000 or 1,050,000 in a new commercial enterprise, and the amount that they invest is going to be either based on it's going to be based on whether or not the business is in what's called a targeted employment area. So that's going to be either a rural area or an area where the unemployment is 1.5 times the national average. And you don't have to make the investment all at once, but you do at the time of applying. All of the investment has to be made. And the primary visa that we see people moving to EB5 is from E2s, right? People who have invested money and then they expand their investment and apply for EB5. There's some things you have to look at, because E2 is not the same as EB5. But for example, the EB5 analysis is going to really quite significantly scrutinize or focus on source of funds. So that's something that it's almost like an audit. When we do an E2, we tend to just kind of gloss over source of funds, but EB5 is quite specific. Also, E2 is going to require that the person owns at least 50% of the entity, where EB5 is not going to require that at all. And then the final thing to point out is that someone who has an E2 business and they're doing really well, the retained earnings of the E2 business can't be counted towards investment. So the investment does have to be external investment that comes into the company. So that's something to keep in mind as well. The other big part of EB-5 is that job creation. So you do have to create 10 full-time jobs in order to qualify for this. The jobs have to be created 2 years after the I-526 petition excuse me, has been approved. So you do have some time to do that. And the money that you invest has to be linked to job creation. So that's another thing to keep in mind when you're looking at this category, is that you can't, like for E2, if you bought, let's say you found a restaurant and the restaurant was $800,000, if you bought it and you said, I want to apply for an E2, that would be no problem. You give the money to the seller, you bought the restaurant has employees, no problem. But for EB-5, that doesn't work. Money has to be invested in the business. There's no link to job creation if the money is given to the seller. So, definitely some considerations you have to work out beforehand. And in terms of this process is a 3-step process where the first part of the process is filing the I-526. The second part of the process is filing the I-485 or consular processing, depending on where you are. Then after you've had the green card for 2 years, you're going to then file the removal of the condition. So it is now the big thing with the EB-5 process is it does take quite a bit of time. If you're investing in a rural area, that is something that they've expedited and they're adjudicating those in around 6 months. But if not, they're adjudicating petitions in closer to the 5-year mark. So, but one great thing is that if you're in the United States, you can file an I-485 petition, and when you file the I-485 petition, you're able to stay in the United States while that's being adjudicated, and you also can apply for work and travel authorization during that time as well. The other green card options, if you're from certain countries, you just take a look at the list. It's coming up again in October. The diversity lottery, so they pick 55 or so thousand people to get green cards every year. So that's something to take a look at. And then definitely there are some humanitarian-based green cards that people have gotten. So helping police solve crime or people who are victims of domestic violence. That's something that has come up. And then, of course, we're always hoping for immigration reform, but that might be something that is very long dated. So whenever you are, moving from a visa to a green card, you're always going to have to look at timing considerations because some green cards take a long time to get. So for example, EB-5 takes a long time to get, and also the perm takes a long time. So you have to make sure that you're maintaining your underlying status, and you have to make sure that you're looking at the visa bulletin to assess whether or not the category is current or will be current, or perhaps will be current by the time you need it. And sometimes you have to look, if I apply for this within the United States, can I travel? Am I able to stay in the US for a period of time? What if I have a sick relative that I have to visit, et cetera? The other thing is, it's not all visas are dual intent. So if you're on an E2 or TN, you have to be careful because you have to really plan the renewal of your visa, because the visa is, if they knew you were applying for the green card and you had to go and renew those, you could run into difficulties. So it's definitely, and sometimes people will have parallel green card strategies where they're looking at multiple different options for green cards. Like so they might be looking at national interest waiver, but also EB-5, or like looking at different options. Perfect. So it looks like that is all of the things covered. And I do see, I'm just going over the questions, and I do see one question here. If an E2 derivative is applied for an immigrant petition for EB-2, what will the visa status of the applicant and spouse during the priority date is not current? Does the E2 visa need to be renewed, or is the employment authorization document good? So I'm not sure 100% trying to understand the question, but if you are applying for EB-2 and you've only filed the I-140, because if your priority date is not current, that means you haven't filed the I-485, then the EB-2 is not giving you any status, right? So the only thing that you are getting is, the only thing that is maintaining your status and giving you status is the E2. So you would have to keep the E2 valid, right? So whether it's renewing it or extending it or whatever, that would have to be valid until the category became current such that you could file the I-485. And how many years this immigrant petition and EAD can be carried, considering priority date will take around 15 to 20 years to be. Well, it can be carried like indefinitely. If you have an E2 and you are just extending it, you can continue, you can do that indefinitely. There's nothing that would stop you from doing that, as long as you were otherwise eligible. And you could even probably go to, especially if the priority date was 15 years out, you could probably go to the consulate and get the visa renewed. That may have some risk, but I think very limited risk given how long the priority date is. Someone else has a question here. Is it recommended to file I-485 and I-140 together for an L1A visa holder who has started working in the US only 2 weeks ago? Well, I think that it depends on how good the application is. I think if it's a strong application, then there's no harm in filing an I-485 at the same time. You're on an L1, so it's a dual intent visa anyway. But I think that what you want to just make sure you're managing is your future visas, right? Because if you file the I-485 and then it was denied, that's your petition that's denied. So when you're later going to fill out visa applications like DS-160s, et cetera, and they ask the question of, have you ever had a visa or application denied? You have to say yes. If an I-140 was denied, that's not your denial. That's company's denial. The company's filed the I-485 on your behalf. Now, the I-140s under any of the categories you're thinking of probably have premium processing. So, I would just do the premium processing, get the answer, and then file the I-485. Maybe that's probably the better way to do it, just to give you some additional options in the future, just in case it's not a strong case. So, because I think that the answer really would depend on how strong the case was. That's when that's when we kind of, we'll always use strategy determinations when we're looking at that. Okay, and I think that's it. I think that's it for questions. So thank you very much for joining us. As I said, we will send you the information that we mentioned, the PowerPoint, the video guides, et cetera. We'll send that through to you. And definitely, if you have any questions in the future, set up a consultation, and we would be happy to help. And then just a few more questions came in. Good morning, attorney. In the TN visa, I'm a TN visa holder as management consultant. You mean I have very slim chance to change my status to a green card? I don't know. So the presentation was based on all of the different mechanisms to move to a green card. So if maybe just refer back to any of those and see if any of those are applicable to you. Thanks a lot for helping in the decision. Appreciate it. Yeah, perfect. So I think that's it. I think that's it with respect to the questions. And again, thank you very much for joining us. And we look forward to dealing with you in the future. If you have, as I say, if you have any questions going forward, definitely feel free to set up a consultation and we'd be happy to help. Thank you. Bye-bye.